Early medieval Europe treated law as something done in the open, in front of people who had to keep living together afterward. When violence happened, the goal rarely stayed private revenge. Communities leaned on formal judgments to stop feuds and restore peace. Authority came from lords, courts, and the church, often at the same time. Justice sounded like morality, and morality sounded like salvation. That link mattered. Religion shaped how wrongdoing got explained. Sin, order, punishment, and repentance sat close together, so a harmful act felt like a tear in the community itself. A court did more than decide facts. It named what crossed the line. It showed everyone that the rules still held, even after bloodshed. Penalties, fines, and public sentences worked as signals. They warned, they soothed, and they closed arguments. In that world, animals did not live at a distance. Livestock moved through the same yards and lanes as children, tools, and food. Pigs, especially, often wandered freely and fed where people lived. The boundary between human space and animal space stayed thin. So when an animal hurt someone, it did not look like an outside accident. It looked like a break in order that demanded a public remedy. In many villages, the problem stopped feeling theoretical. Pigs moved through lanes and yards, mixed with children, and ate whatever lay within reach. When something went wrong, it went wrong fast. And the complaints changed tone. People no longer described only a loss or an injury. They began to name the animal itself, as if it had chosen the act, as if it could be singled out and answered. That shift mattered because naming created a target everyone could point to. Not a vague misfortune, not just an owner's carelessness, a specific creature marked as the cause. In crowded places, that felt like the only way to keep the peace. Without it, anger spread to families and neighbors. Retaliation tempted people, and retaliation never stayed small. One violent incident could start a chain. Then a case arrived that shocked even people used to hardship. A roaming pig killed a small child. Grief turned into outrage, and outrage demanded an answer that looked bigger than personal revenge. The community needed something public, something that declared what counted as order. So the push grew for an official response. The animal had to be called out, not just chased off or quietly butchered. In the next step, the response stopped being informal and turned into procedure. Authorities chose to treat the animal's act as a case that belonged in court. That meant summonses went out, not rumours. Witnesses appeared, accounts were taken, and details were fixed into writing. The point was not to guess what the animal meant. The point was to handle the harm the way society handled harm, through a recognised judgment. This looked on purpose like a human trial. People gave sworn testimony about what happened, where it happened, and who saw it. The court weighed those statements as evidence, not as village gossip. By putting the facts into a record, officials made one version of events official, and they made it harder for the community to split into competing stories. A court did not just punish, it decided what counted as truth. The logic at the time was blunt. A public injury demanded a public answer. Without a verdict, anger could turn into feuds, and fear could turn into panic about what else might happen. A sentence restored the idea that order still held, even after something shocking. And it sent a warning beyond the animal itself. Negligence had consequences. If animals were allowed to roam, then owners and neighbours had to feel the weight of that risk. By this point, the court did more than hear witnesses. It treated the animal like a real defendant. Officials identified the exact pig, not just any pig, and that detail mattered. The accused animal got taken into custody, held so it could not disappear, get swapped, or get quietly killed. Procedure became the message. This was not a mob response. This was justice, performed step by step. In a documented French pig case, the trial day followed a familiar rhythm. A formal complaint got read, and the charge was stated plainly. The pig had attacked and killed a child. The court recorded names, dates, and the owner's connection to the animal because responsibility hovered over every line. In some cases, a legal representative was appointed to speak for the pig, so the hearing kept the shape of fairness. Then came the decision, framed as judgment, not vengeance. The magistrate weighed the testimony and tied it back to the charge, as if intent mattered less than the public harm. The sentence got pronounced on the animal itself, with the owner's role handled separately when needed. The point was legitimacy. Once the court spoke, the community got a single official answer, and the case moved from outrage to closure. Once the verdict came down, the case still was not finished. The sentence needed to be seen, so punishment moved out where the community could witness it, and it followed the same pattern used for people. A pig that killed a child might have been led out and executed under official supervision. This did not happen quietly. The point was public finality. The law had spoken, and everyone needed to know it. These executions worked like a kind of closing ritual. Villagers had lived with the fear, the anger, and the gossip that followed a violent death. A private killing of the animal could have looked like revenge or panic. A staged communal punishment looked like order. It showed that the harm had been recognized and answered in the proper way. In that moment, outrage became something managed. The community moved from shock toward a controlled ending, and the message reached beyond the animal. The spectacle drew a clear line around what the community accepted and what it rejected. A dangerous act, no matter who committed it, had been named as wrong and met with a visible consequence. It warned owners as much as it condemned the pig, because everyone understood how easily negligence could turn into tragedy. The execution said this was not normal village life. This crossed a boundary, and the boundary held. By this point, one pattern seemed clear. A dangerous farm animal could be pulled into a human courtroom. But medieval Europe did not treat every animal case the same way. The key difference turned on where the threat came from. A domestic animal lived inside the village economy, owned, traded, and controlled, at least in theory. So its violence belonged to secular justice. A swarm that ate the harvest felt different. It looked less like crime and more like affliction. A village pig trial followed the familiar track. Officials named the animal, took it into custody, heard witnesses, and produced a sentence the community could recognize. The point was order. A clear ruling, a visible outcome, and pressure on owners to restrain what they kept. But that system depended on one assumption: that the accused could be treated like a single defendant. With pests and invertebrates, that assumption collapsed immediately. When insects or other small creatures arrived in numbers, the case often moved to church authority. There, the response used religious tools rather than prison cells. Clergy issued formal warnings, pronounced bans, and sometimes performed rituals, described as excommunication, aimed at driving the infestation away. It sounded like a trial, with declarations and deadlines, but the goal shifted. Secular courts punished an individual animal. Ecclesiastical action tried to protect the community from a force that could not be arrested. Over time, the courtroom response to animal violence stopped being only a local habit and started raising harder questions. If a pig killed a child, who carried the blame? The animal that bit, or the owner who let it roam? Some officials still treated the animal as a wrongdoer. Others leaned toward negligence and control. A new tension emerged. The law had to choose between agency and supervision. That tension pushed legal minds into finer distinctions. Harm alone once seemed enough to justify punishment, but intent mattered in human law, and animals could not explain motives. Some arguments treated the animal as a dangerous body that needed removal, not moral judgment. Others insisted the public verdict still restored order, whatever the animal understood. Each case forced a calculation, punishment as justice or punishment as prevention. What made this shift visible was paperwork. Court registers listed charges, witnesses, and sentences. Notarial acts recorded ownership, custody, and costs. Some texts even summarized reasoning, preserving the push and pull between human responsibility and animal culpability. These were not campfire stories. They were administrative traces that survived in archives. And in those lines of ink, historians later watched custom turn into jurisprudence. By the late Middle Ages, that old certainty began to crack. Courts still existed, but they changed shape. More cases ended up in the hands of trained judges, clerks, and lawyers who treated procedure as a craft, not a local ritual. They asked different questions. Not just what happened, but who controlled the risk. When an animal harmed someone, responsibility slid away from the creature and toward the people who kept it. Towns also tightened their grip. Urban councils wrote ordinances, hired watchmen, and punished owners for letting animals wander. Stray pigs stopped looking like a mysterious threat and started looking like a failure of governance. The solution no longer needed a defendant with 4 legs. It needed fines, impoundment, and rules that could be enforced day after day. As streets grew busier, preventing harm mattered more than staging judgment after it. At the same time, newer ways of thinking undercut the old logic. Learned writers leaned toward natural causes and predictable behavior, not moral choice in animals. Harm became something to manage, not something to condemn in a courtroom drama. So the trial of the animal began to feel unnecessary, even embarrassing. A professional legal system preferred clear human accountability, and a changing culture preferred practical control over symbolic verdicts. By the time the old prosecutions faded, they stopped looking like law and started looking like a strange story. Later centuries treated them that way. Writers repeated the most shocking details, and each retelling pushed the cases further from their original purpose. A pig in a village file turned into a symbol of medieval madness. The trials survived, but often as entertainment, not evidence. That shift mattered because sensational stories travelled farther than paperwork. Collections of curiosities mixed real incidents with rumours, swapped dates, and combined separate cases into one dramatic scene. The animal became the main character, the crowd became a mob, and the court became a stage. The more unbelievable it sounded, the more it got copied, and soon people knew these trials without knowing any single case. So historians went back to the only place that could settle it. The records. The strongest proof came from court registers that logged charges and hearings, from written sentences that named punishments, and from chronicles written close to the event by local observers. Everything else counted differently. Later retellings, moral anecdotes, and second-hand summaries often embellished. The rule became simple. If it could not be traced to a document, it stayed a story. Today, no European court treated an animal as a defendant. No pig faced a judge, no swarm received a sentence, and no execution ended with a legal record that named the creature as the guilty party. Yet the paperwork survived. Old registers, verdicts, and expenses stayed in archives, and modern readers returned to them with a different purpose. They looked less for spectacle and more for what these cases revealed about how medieval people built order. Historians studied these files because they showed how justice had worked when law needed to be seen and shared. The point was not simply to remove a dangerous animal. The point was to announce a rule, assign meaning to harm, and calm a community that demanded an answer. Even the mistakes and contradictions mattered. They exposed a world where courts tried to balance fear, faith, and daily survival in villages where animals moved through human space. Those documents also mapped a changing boundary between humans and animals. In the medieval setting, a roaming pig could be treated as a legal person for the moment it broke the peace, and a court could act as if the animal belonged inside the moral order it defended. Modern law worked differently. Harm still triggered investigation, but responsibility fell on owners, employers, and institutions. The animal stopped being the accused and became evidence.